All right, we're continuing on with leasing real property, Chapter 7, creating the tenancy. In the background, you will hear my partner playing the saxophone because he is a professional musician. And he is also working from home. Okay. I wanted to quickly go over non-freehold estates. So we mentioned that there is a difference between non-freehold and freehold estates, and I told you all to think of non-freehold estates as leases. Well, this is a little bit of a more formal definition. Non-freehold estates are estates granting possession but not ownership to its holder. Again, they grant possession but not ownership. So they differ from freehold estates because freehold estates do grant ownership and possession. All right, there are 4 types of common law non-freehold estates. The first is the term of years the first is term of years tenancy. The second is a periodic tenancy. The third is a tenancy at will. And the fourth is a tenancy at sufferance. A term of year tenancy has a fixed duration, and that's agreed upon in advance, and the right to possess the property ends at the expiration of that term, and the landlord automatically has the right to enter and retake the possession of the premises. So again, it has a fixed duration. The tenant's possessory rights end automatically at the expiration of the term, and the landlord can retake the possession of the premises at that time. This differs from a periodic tenancy. A periodic tenancy is one that's automatically renewed for a specified period of time, and it's renewed until the landlord and the tenant terminate the tenancy by giving advance notice. So an example of a periodic tenancy is, let's say, L leases Green Acre to Tom from month to month, beginning in July. So in this case, we would have a month-to-month tenancy, a periodic tenancy. Okay, so a tenancy at will is a tenancy that has no fixed ending point. It continues on so long as both the landlord and the tenant want it to. At common law, the landlord or the tenant could end a tenancy at will without notice. But most states now require some type of advance notice to protect tenants. This type of tenancy ends automatically if either of the parties die, the tenant abandons possession, or the landlord sells the property. Finally, a tenancy at sufferance. The tenancy at sufferance is created when somebody who rightfully took possession of a property continues to possess that property after their right to possess has ended. So they're considered a holdover tenant. Now, it's important to note that this is not a squatter. This is somebody who took the property based on the rightful possession to take it, right? So they differ from squatters in that sense. All right, so again, non-freehold estates. The distinction among non-freehold estates is that they're different based on their duration. Why does this matter? Well, the type of estate is going to affect both the procedure for ending the estate and it'll affect when the estate actually ends. So, for example, if you have a periodic tenancy, you need to give appropriate notice before you terminate a periodic tenancy. But if you have a term of years tenancy, it ends automatically when the term expires without any notice. So that's why it's important to determine what type of non-freehold estate you have. So now we're going to talk about the landlord's duty to deliver possession. So this is still, we're finishing up creating a tenancy, and we're talking about the landlord's duty to deliver possession. Before we get into a discussion about the case that we read on this topic, I'd like to spend a moment talking about what exactly possession is. So possession has two components to it. One is having the legal title to, the legal right to possess, right? The legal right to possess. And the other is having actual possession of the property. So you can have the legal right to possess property, but not have actual possession. And you could have actual possession without having a legal right, right? So when we talk about the landlord's duty to deliver possession, the question is, what type of possession does the landlord have a duty to deliver? All states require that the landlord deliver the legal right to possess. All states require that. But not all states require that the landlord deliver physical possession. Okay. So how do you determine whether a landlord needs to deliver physical possession then? Well, first you look to the contract. Then if the contract is silent, you're going to look to the default rule in that state. So the default rule is going to be either there's a split in jurisdictions between what's called the English rule and the American rule. And we're going to go over that when we talk about Keydata Corp v. United States. So let's go ahead and discuss it. All right. There should be a video here that appears not to be popping up. Excuse me while I fumble. In an unfortunate turn of events, it appears that the video will not play. The Keydata Corp v. United States video is meant to help you try to sort through the facts of the case. So I'm going to have to end this video here and then present the other video separately. Okay, looks like we have the video loaded. So I'm going to go ahead and go through the facts of Keydata Corp v. U.S. Wyman was the landlord of this in this case, and Keydata and the government were leasing property from Wyman. Specifically, the property at issue is a computer lab, which I'm representing here in this little house. So Wyman rented this computer lab over to Keydata. Keydata used it for a period of time, and when they used it, they improved upon it. They spent about $39,000 to add improvements on the property. Now, these were fixtures they could have taken with them, but when they decided they needed more space, they realized that the government could use the improvements that they made onto the property. Keydata wanted to get out of their lease early, so they found the government to take over their lease, essentially. But to do that, they first had to amend their lease with Wyman. And Wyman then entered into an agreement with the government. So the government got the computer lab plus the improvements, or they were meant to get them. They contracted for them. And in the agreement, the government agreed to pay Wyman $39,000 extra for the improvements. And Wyman then agreed to give $39,000 to Keydata. Okay. But unfortunately, that all didn't happen. I apologize for the multiple presentation types, but I'm having a lot of technological issues today. So we're going to go forward with Keydata Corp v. US. The issue in this case, like we said, was whether or not Wyman needed to deliver physical possession of the leased premises in addition to the legal right of possession, which it had failed to do, right? The court says that because this is a government contract, a government procurement contract, then federal law should apply, and federal law has been silent on the issue. So they take a look at the split in U.S. law. There's opinions in some jurisdictions that follow the so-called American rule, and then there are opinions in other jurisdictions that follow the English rule. So the difference between the American rule and the English rule. The American rule says that the landlord simply has to transfer the legal right to possess the land. They do not need to actually transfer physical possession to the tenant. The English rule says that the landlord must deliver both the legal right to possession and the actual physical possession of the premises. The court weighs the public policy arguments for both and finds that the English law is the one that has the most benefits. So that is what they apply. So the court found that the lessor needed to have delivered physical possession, and they did not. Wyman did not. And that is it for Keydata Corp and the discussion of possession. I guess aside from one more thing, which is let me give you a overview. If you get a question where you have to decide whether the landlord breached his duty to deliver possession, then what you're going to do is you're first going to look to the contract, because this is an area that allows for variation, a deviation from the standard rule. So first you look to the contract. If the contract is silent, then you are going to, if you don't know what the jurisdiction, which rule they follow, which you probably won't on a essay question, you're going to need to apply both the American rule and the English rule to the problem. So that is how you would approach an essay problem. All right, stay tuned for conditions of the premises coming next.